Greetings. This is the Florida Populist channel with Jeff J in Tampa Bay, where it's sunny and warm and never the norm. We emphasize local Florida, city, county, and state politics and law as it relates to economic freedom, individual liberty, and following the Constitution. District of Criminals, go home. Let us alone. Before I get into part two, I have to give David Happy of the Pirate Podcast a huge shout out. There's a reason why he's been nominated for Best of the Bay, or I believe he's a candidate for it. There's a reason for it. Excellent show. Sub to the Pirate Podcast, Pirate America on IG, Pirate Podcast on Facebook, and he's on various platforms. Also, Florida Girl YouTube channel, if you're looking for really fine-tooth comb Pinellas County specific politics. She goes through these long, drawn-out, boring Pinellas Commission meetings, but then distills like those big gold nuggets that you need to hear. Very unique channel, very needed content. So definitely subscribe to Florida Girl on YouTube. Also, if you're in Pinellas County and you want to get with us like-minded folk, join Community Patriots Pinellas. Or if you're in Manatee, there's Community Patriots Manatee as well. For Hillsborough, there's only two I'm aware of. There's Tampa Bay Young Republicans, and there's the Blexit Foundation, blexitfoundation.org. You can join a chapter, the one in Hillsborough. I believe there's one in Pinellas too. So yeah, there's Tampa Bay Young Republicans for Hillsborough, and then here in Pinellas, there is Pinellas Young Republicans as well. So check them out, and with no further ado, I'm going into part two of the closing argument against the City of Gainesville's vaccine mandate by attorney Jeff Childers. Part two. This court must immediately grant the injunction. What I'd like to do here in part two of my argument is briefly describe the 5 assertions that prove beyond argument that this court must immediately grant the injunction, and then I'll circle back and discuss the law related to each of the 5 sections in further detail. Assertion 1. The United States Supreme Court directs lower courts to test a compelled vaccination law against the Constitution of the individual state. That's in the case of Jacobson versus Massachusetts. Assertion 2. Compelling an unwanted medical treatment violates Florida's right to privacy in Article 1, Section 23 of the Florida Constitution, and citizens' right to refuse unwanted medical treatment in the cases of Browning, Green, Lewis's dissent in Green, and Makovec. Assertion 3. If a challenged law merely implicates Florida's right to privacy, the burden automatically shifts to the government to prove that the law furthers a compelling state interest in the least restrictive way, also known as the strict scrutiny standard, in the case of Green and Gainesville Woman Care. Assertion 4. The high strict scrutiny standard applies equally when the government enforces laws and for government action as an employer to enforce a workplace policy, in the case of Kurtz. Assertion 5. The vaccine mandate is presumptively unconstitutional because it violates Florida's Constitution. The city offered no witnesses or evidence to overcome this presumption. An injunction barring the vaccine mandate must issue as a matter of law. Case law precedent, Gainesville Woman Care. Let's look at those assertions one by one. Assertion 1, state law governs compelled vaccination. As I mentioned before, the city relied heavily on Jacobson in its brief. The city probably shouldn't have brought up Jacobson because the case helps the plaintiffs, not the city. It could not be more clear. Jacobson holds that the state law governs compelled vaccination. In that case, the court was considering a $5 fine on Massachusetts citizens who refused a compulsory smallpox vaccine. But even Massachusetts wasn't compelling anybody to take the vaccine. You just had to pay a small fine if you didn't take it. You could opt out by paying a minor ticket. They weren't holding anybody down and sticking needles into them or anything. And they sure weren't terminating people's employment, deleting their retirement benefits, and destroying their livelihoods. But anyway, somebody sued over that $5 fine and took it all the way up. And the United States Supreme Court said, quote, "This court has distinctly recognized the authority of a state to enact quarantine laws and healthy laws of every description. The mode or manner in which those results are to be accomplished is within the discretion of the state." End quote. Back to Jeff's closing argument. Then, the Supreme Court looked at Massachusetts state constitution and discovered law that authorized the fine for rejecting a compelled medical treatment. Massachusetts didn't have an explicit right of privacy in its constitution. Still doesn't. Jacobson says you must look to state law. All right. The Supreme Court, applying the same Jacobson principles, would have to come out the opposite way. Why? We come to the second assertion. Assertion 2, the right to privacy. The majority in Green and the dissent didn't agree on much, but they did agree on one thing. Compelled medical treatments violate the Florida Constitution. No question. It's not even close. Judge Lewis explicitly affirmed that Florida's constitutional right to privacy includes the right to refuse medical treatment. So the city was right about one thing. This case isn't about the right to stay unvaccinated. This case is about a Floridian's absolute right to refuse unwanted medical treatment. That's what this case is about. Judge Lewis isn't the only judge who disagreed with the majority holding in Green, that mandatory masking is presumptively unconstitutional. Now, I think Green and Makovec can be reconciled. But, in a footnote, the majority in Green acknowledged the possibility of a split between the first DCA and the fourth DCA in Makovec. And Judge Lewis cited Makovec fairly heavily for that case's language about masks in his dissent. But you know what? Both Green and Makovec agree on one thing. Compelled medical treatments violate the right to privacy in the Florida Constitution. Here's how Makovec concluded. Quote, thus, requiring facial coverings to be worn in public is not primarily directed at treating a medical condition, as EO 12 does not implicate the constitutional right to choose or refuse medical treatment. The trial court correctly applied the rational basis standard of review to appellant's challenge to the ordinance. Appellant's sole argument on appeal fails because they did not establish that the order mandating the wearing of face coverings intrudes on their constitutional right to refuse medical treatment. End quote. So anyway, it's not just the first and fourth DCAs who explicitly recognize the right to refuse medical treatment. Our Supreme Court has also recognized that right over and over. Here's what the Florida Supreme Court said in the Browning case. Quote, everyone has a fundamental right to the sole control of his or her person, as Justice Cardozo noted 76 years ago. Every human being of adult years and sound mind has a right to determine what shall be done with his body. An integral component of self-determination is the right to make choices pertaining to one's health, including the right to refuse unwanted medical treatment. Recognizing that one has the inherent right to make choices about medical treatment, we necessarily conclude that this right encompasses all medical choices. A competent individual has the constitutional right to refuse medical treatment regardless of his or her medical condition. Regardless of their condition. Regardless. End quote. Back to Jeff's closing argument. The bottom line is citizens have the right to refuse unwanted medical treatments regardless of their condition. Under Article 1, Section 23 of the Florida Constitution, and if the government punishes or discriminates against a citizen for accessing that right in any way, the government violates the Constitution. So what happens to the burden of proof when the right to refuse medical treatment comes into play? That's assertion number 3. Assertion 3, the right to privacy. If the right to refuse medical treatment comes into play, then citizen plaintiffs don't have to prove anything to get an injunction. The citizen plaintiffs are presumed to be right. The burden shifts to the government to prove it has met the high, strict scrutiny standard, a standard that requires it to somehow prove the negative, that there are no other means less restrictive to further its compelling state interest. Maybe in most situations, the plaintiffs would have to prove something. But Green, binding on this court, says this about injunctions in privacy cases. Quote, the Supreme Court has said that the analysis is entirely different when a temporary injunction motion is based on a privacy challenge. The right of privacy is a fundamental one, expressly protected by the Florida Constitution, and any law that implicates it is presumptively unconstitutional, such that it must be the subject to strict scrutiny and justified as the least restrictive means to serve a compelling governmental interest. A plaintiff does not bear a threshold evidentiary burden to establish that a law intrudes on his privacy right and have it subjected to strict scrutiny, if it is evident on the face of the law that it implicates this right. End quote. Back to Jeff's closing argument. So it is clear that citizens have the right to refuse unwanted medical treatments, and if the government's law invades that right, it is presumed to be wrong. And it has the burden of proving the negative and that it meets the very high strict scrutiny standard. But the city didn't try to prove anything today. Not strict scrutiny, not even a rational basis. Nothing. That means the city loses. If it doesn't put on evidence, then it has failed to meet its burden, and the injunction must issue as a matter of law. It's happened before. It happened in the Gainesville woman care case, heavily cited in green. In that case, the Supreme Court said that because the government didn't put on any evidence, it was game over. Quote, "It would make no sense to require a trial court to make factual findings regarding a state's compelling interest, as the First District would require, when the state presented no evidence from which a trial court could make such findings." End quote. Back to Jeff's closing argument. So why didn't the city attempt to prove its vaccinate or terminate policy passes strict scrutiny? Because it says only citizens have constitutional rights, and like pre-constitutional George Washington, the city doesn't look at its its employees, as citizens. The city says that it can ignore the Constitution, the governor, the legislature, and the attorney general because it is a corporation, a municipal corporation. But that's not what the Supreme Court said. Assertion 4, the rights of government employees. There are really two parts to the city's argument that it escapes constitutional scrutiny when it acts as an employer. The first part is that it should be treated the same as a private employer. Because private employers aren't subject to constitutions, which after all are limits on the government's powers. The second part of its argument is that the city says, hey, the vaccinate or terminate policy isn't a law, it's just a policy, expressly arguing that the governments can escape constitutional limits by calling things, quote, policies, end quote, instead of laws. In other words, executive actions independent from the legislature aren't bound by constitutions since they aren't laws. But the Florida Supreme Court already handled these arguments in Kurtz. So in Kurtz, the Supreme Court was reviewing the city of North Miami's policy, not a law, of asking job applicants if they had smoked cigarettes within the prior 12 months. Somebody objected to that and sued. The Supreme Court analyzed the city's policy under Article 1, Section 23 of the Florida Constitution. Listen to how the Supreme Court described the policy. Quote, to reduce costs and to increase productivity, the city of North Miami adopted an employment policy designed to reduce the number of employees who smoke tobacco. In accordance with that policy decision, the city issued Administrative Regulation 1-46, which requires all job applicants to sign an affidavit stating that they have not used tobacco or tobacco products for at least 1 year immediately preceding their application for employment. Once an applicant has been hired, the applicant is free to start or resume smoking at any time, end quote. Back to Jeff's closing argument. Reducing costs and increasing productivity. Sound familiar? It should. It is the same argument that the city of Gainesville is making. But the point is, the Supreme Court analyzed the city of North Miami's policy under the Florida constitutional right of privacy. It's policy, not a law. But what about the argument that the Constitution doesn't apply to government when it acts as an employer? Listen to what the Supreme Court said in its very first footnote in that case. Quote, notably, because Florida's constitutional privacy provision applies only to government action, the provision would not be implicated if a job applicant was applying for a position with a private employer, end quote. Back to Jeff's closing argument. See that? The Supreme Court makes a clear distinction between a government employer and a private employer. It says the constitutional right of privacy wouldn't be implicated for a private employer, but it is implicated for a public employer. The Supreme Court in Kurtz even found that employees can have even more constitutional protection once they've been hired by a government employer than they have as free citizens applying for government jobs. Listen to what the Supreme Court said. Quote, notably, we are not addressing the issue of whether an applicant, once hired, could be compelled by a government agency to stop smoking. Equally as important, neither are we holding today that a government entity can ask any type of information it chooses of prospective job applicants, end quote. Back to Jeff's closing argument. That seems pretty clear. Government employees still have rights even when the government is acting as an employer. Next, listen to how the Supreme Court described the analysis that must be undertaken when a government, acting as an employer, potentially invades a citizen's right to privacy. Quote, thus, to determine whether Kurtz, as a job applicant, is entitled to protection under Article 1, Section 23, we must first determine whether a governmental entity is intruding into an aspect of Kurtz's life in which she has a legitimate expectation of privacy. If we find the affirmative, we must then look to whether a compelling interest exists to justify that intrusion, and if so, whether the least intrusive means is being used to accomplish the goal. Back to Jeff's closing argument. In Gainesville Woman Care, the Supreme Court explicitly said that the right of privacy holds regardless of the nature of the activity. In other words, it doesn't matter if it is government acting as an employer, citizens still retain their fundamental rights. Quote by the Supreme Court, it is settled in Florida that each of the personal liberties enumerated in the Declaration of Rights is a fundamental right. Legislation intruding on a fundamental right is presumptively invalid and, where the right of privacy is concerned, must meet the strict scrutiny standard. Florida courts have consistently applied the strict scrutiny standard whenever the right of privacy clause was implicated, regardless of the nature of the activity. Gainesville Woman Care repeats the same proposition, holding that strict scrutiny applies to any law implicating the right of privacy. Quote, this court applies strict scrutiny to any law that implicates the fundamental right of privacy, end quote. Back to Jeff's closing argument. That even includes laws or policies by government agencies when acting as employers. There aren't any exceptions. It doesn't say any law except when the government is acting as an employer. It says any law. In other words, the employees retain the rights to their own bodies. The city does not have any right to treat their bodies as property. The city also argues that it's just conditioning employment on vaccination. It's not holding people down and giving them shots or anything. It doesn't matter. It is Hornbook law that public employees don't have to choose between their constitutional rights and having a job. One case put it this way, quote, because Richmond Public Schools recommends termination when an employee refuses urinalysis testing, Robertson had to choose between losing his job or submitting to the urinalysis test. That choice was not a choice at all. Robertson versus School Board of City of Richmond, Virginia, 2019 case. Back to Jeff's closing argument. The 11th Circuit agreed in a case by Robertson. It reiterated the same point. Quote, employees who must submit to a drug test or be fired are hardly acting voluntarily, free of either express or implied duress and coercion, end quote. American Federation of State, County, and Municipal Employees and Council 79 versus Rick Scott, 11th Circuit, 2013. In the Scott case, the court described the holding of a U.S. Supreme Court case like this, quote, the government cannot require its employees to relinquish their Fifth Amendment rights on pain of termination because the option to lose their means of livelihood or to pay the penalty of self-incrimination was the antithesis of free choice. Garrity versus New Jersey, 385 U.S. 493, 1967. Back to Jeff's closing argument. We have already seen that all Florida courts agree compelled medical treatments intrude into a citizen's legitimate expectation of privacy. The conditioning of employment on a waiver of constitutional rights impairs those rights. Therefore, this court must apply strict scrutiny to the city's vaccine policy. It must. Assertion 5. The injunction must issue as a matter of law. We have seen that the vaccine mandate is presumptively unconstitutional because it violates Florida's Constitution. Because the city offered no witnesses or evidence to overcome this presumption, the court must issue an injunction barring the vaccine mandate as a matter of law. Green stated plainly that when the government fails to put on evidence of its compelling state interest, it is game over. Here's how Green, citing Gainesville Woman Care, put it, quote, when the government fails to offer evidence to demonstrate a compelling state interest, the trial court then is absolved of having to make any finding to that effect, end quote. Back to Jeff's closing argument. No findings are required. Green also teaches that after the court makes a threshold determination that the constitutional right of privacy is implicated, the remaining prongs of the inquiry collapse into the first prong. That means that the court must presume the elements necessary to obtain the injunction have been met, that irreparable harm is likely, 2, that an adequate remedy at law is unavailable, 3, that public policy favors the injunction, and 4, that the plaintiffs are substantially likely to prevail on the merits. Here's the bottom line. 1, compelled medical treatments like vaccination policies violate the fundamental right to privacy. 2, Kurtz teaches that in Florida, at least, government employer policies are subject to the fundamental rights of privacy and bodily autonomy. 3, therefore, the burden shifted to the city to prove its policy meets strict scrutiny. 4, the city failed to offer evidence to demonstrate a compelling state interest. 5, the court doesn't have to make any findings. 6, the court must presume that the elements necessary for the injunction have been met. The injunction should issue today. There's nothing to think about. There's no findings to be made. Absent evidence of a compelling state interest and use of the least restrictive means, and since it is clear that under Kurtz that the government is subject to the right of privacy even when acting as an employer, this is a very simple case. I would like to incorporate the other arguments from our reply, filed Friday, into this argument, particularly the arguments about Florida's vaccine passport ban, which, as the Attorney General indicated in her amicus, makes the city vaccine policy illegal by statute. Judge, on behalf of my 250 clients, the plaintiffs, we are asking you to immediately issue the injunction. Thank you. District of Criminals, go home. Let us alone.